I get to respond?
That was a question.
Yeah. So great. So I just wanted to respond to that question. So, so yes. So of course, I sometimes teach legal and political philosophy, and one of the things that I try to impart to my students is that any good theory that will stand the test of time, you should be able to communicate it to a child in a way that they can understand. And so I think the social contract theory has been with us for so long because even a child can understand that we should keep our promises. If you promise to give up your right of nature or to enter into a society with others and respect the commands of your sovereign, you have some obligation to do so. The fiduciary or trusteeship model trades on a similarly equally basic intuition, one that I'm embarrassed to say many of us will know from the comic series Spider-Man. From Uncle Ben. With great power comes great responsibility, right? That's sort of what underlies this. That's really what underlies, to some extent, this model. So as much as I would have sold many more books with, after the colon, a Spider-Man theory of the state, I resisted that. But I do, share this with my students. But the upshot is that yes. So I think Indigenous peoples, vis-a-vis their own members, have obligations, and I think their leadership, to the extent that I'm, one's always a bit uncomfortable talking about, this not being a member, but from my reading of the cases, my reading of the way in which their assemblies work, the way in which their elders justify their decisions, it looks very judicial. In the way that these things proceed. Individuals, when they have disputes, seem to be treated equally. Individuals are treated with respect to the extent that they're given reasons for the decisions of public authority. So the quick answer to your question is yes, there is a responsibility implication that comes back on Indigenous peoples themselves vis-a-vis their own membership. Now, I do want to just one quick comment that I think Hanek's really helpful discussion has, again brought to the surface that's sort of been underlying many of the discussions that we've been having for the last day and a half. So if we think back again to the questions that Yale put on the board, it's how can we reconcile state sovereignty with obligations to others? Is it a good idea for us to do so, to think of state sovereignty as being reconciled with these obligations to others? Underlying the question that's sort of underlying these questions is what is actually the model of authority that gives public authorities or purported public authorities the right or the authority to make claims on others, make claims such that when they make those claims, then they have certain obligations to contend with. One answer is, well, there has to be some sort of consent of the governed vis-a-vis those who are governing them, but that's very difficult. I think that's a very difficult case to make with respect to foreign nationals. I think it's a next to impossible case to make in the case of Indigenous peoples. And so we have to think of another model that perhaps isn't based on consent but picks up on the idea of legal authority or legality, as David was discussing it, that can still make sense of how public authority can announce and exercise itself in a way that does not pose or produce domination over those who are subject to it.
Okay, I have many questions in my list, so let's take two at a time. So Jean and then Lior.
Okay, this brings us back to a question I've had and never obviously articulated well, since nobody ever answers it or even addresses it. But anyway, this is the question. So clearly we're talking about legal obligations, not moral ones.
Both.
I still don't. Fine, but not only moral ones. But I'm wondering what work the word trusteeship does and why you need it,
Right.
Given its baggage. Now, it was an interesting distinction, Hanoch, is that your name? That you made about, I think it's really important that vis-a-vis foreigners, there's no shift of authority from foreign. This is crucial. Now, with indigenous peoples, we all know they were occupied, among other horrible things, and we didn't let them, in the United States at least, we didn't consider them as potential members of the Federation, even before it was a federal state that was being developed. Why not? We know why not, but that would have been a model in which the problem would evaporate. The Federation members are not under trusteeship. It's constitutional pluralism, but it's not trusteeship, right? And so the fact that you have to resort to that tells you something about the relationship that's still problematic, as we all know perfectly well. So, okay, here's the way I understand trusteeship. Private law person, maybe this is where it comes from. I'm not a lawyer, but somebody has to explain to me how this works. So there's a beneficiary, there's a trustee, subject to abuse. Obviously, the beneficiary, like a child and a son, obviously needs some kind, as you said, needs some kind of some other person with qualifications doesn't have, etc. That's already a non-egalitarian relationship, presupposed. And then there's supposed to be, isn't there a third-party regulator, supposedly, of this trustee? So if you have a trustee for a person who has a trust and then they're going to grow up and get, obviously the law of the state is a third-party regulator. So who's a third-party regulator? What is it, international law? But apart from that, why use this model for a relationship between, in this case, indigenous peoples and the sovereign state that still rules over them in a way that they'd rather it didn't, I suppose. Why, I mean, maybe you use it because it is, in the pejorative sense, a trusteeship model, not the way you would want it to be. So that's my question. And my second question is, what about these three levels vis-a-vis all use of the trusteeship thing, if we're talking about a legal fact?
Yeah.
I think can you pass that to Leora? Thanks.
Thank you. So, if I understood why use the model of trusteeship with indigenous people, is that they ask collective rights and so forth. So it's more than an individual citizen's right. But that brings me to the question: suppose we have a group of indigenous people who is not split according to the territorial border of a state. Half of them are here in Israel. Half of them are in Jordan. They are the same group, and the state builds this project that has a tremendous effect on both of them. But the project is within its borders, right? Why is it? I don't understand why is it that we have to treat them differently from your perspective. Because it seems to me that your perspective begins with the people and not with the idea of trusteeship and citizenship. So it seems to me that the model of trusteeship for humanity takes down the obligation that you would think if you begin with the indigenous people themselves. And also with one of the examples you gave with the corporation, it was clear that the obligation is on the Ecuadorian state and not the corporation. But why is it? If we begin with the corporation, then maybe the corporation has the same obligation towards both sides of the border, while with states we are stuck with this border thing. So I'm just pushing you to see how much you fit with this model.
Okay.
We have so many on the list, so try to be as
super quick.
So
Jean, let me just lay my cards on the table. The relations, so I think the trusteeship model applies all the way through, not just with indigenous people. I think indigenous people pose a particularly hard case, but I think it works for citizens too. And you might think, well, why does it? It's like it's this asymmetrical, non-consensual relationship. And the simple answer is because the fundamental legal relations between states and individuals is asymmetrical and non-consensual. And the trustee model is the only one that gives, I know we can't believe it because we're Democrats, but here's the secret, though. The state doesn't care whether you consent. It doesn't matter.
The third party in that case is a citizen.
No, the third party is the law. So where the authorization comes from, of the public trustee power is the law. It's a fiduciary principle or a principle of trusteeship that authorizes power to be exercised, but only subject to certain terms. Only subject to certain terms. That's the only way that we can make sense, in my view, of the obligations that a state has to somebody who comes to the border who's never participated in the democratic politics of that state. Now, with respect to indigenous peoples, we have to go up a level, and the authorizing body of law here is international law, and its institutions operate to regulate in much the way that you say. But within this realm of legal authority, the real trick, and we don't we feel a bit uncomfortable about this because we're all Democrats, but the real trick is explaining non-democratic authority. That is authority that has nothing to do with whether people actually consent to it or not. Now, when we go to Leora's question about individual citizens, say some are in Israel, some are in Jordan, the answer I'm going to give builds on what I said to Jean. The legal principle that authorizes the Israeli state to go forward with a project that will affect third parties outside the Israeli state is again a trusteeship principle, but it's a trusteeship principle that operates by law on behalf of exactly all the people who will be affected by the exercise of power of whoever the power holder happens to be. Now, if it's the Israeli state that's engaged in this project that has extraterritorial effects, those people are comprehended as beneficiaries within a broad trusteeship relationship that includes the Israeli state as the power holder and has them as beneficiaries that should be treated in the same way as Israel citizens would be treated with respect to this particular project. I mean, that would be the answer. You may not find it. Why don't they have a veto like indigenous peoples? That goes to the special claims of indigenous peoples You're saying a tribe? Well, then they should. Then it should be cross-border. No. If they're indigenous peoples, they would have the veto. Yeah. So this has to do with a more complicated question about why does indigenous difference make a difference, and who count as peoples at international law. But that's a question that I think has to be that can be separated and answered one way or the other independently of the trusteeship model.
Okay, let's take three. Andrew, Eyal, and Sergio.
Evan, thanks. I really enjoyed your paper, and not only because of its similarities with my own, and actually particularly because I think you take instead of just making a negative case, you try to engage constructively with Eyal's problems. My question is, and it really is a question, it's just that I like the contrast you make between the case of consultation and the case of the veto. And I understand how when we're talking about consultation, we're talking about trusteeship. But it seems to me once the indigenous people have a veto, it doesn't seem to me any longer like a case of trusteeship. You described it yourself as sovereignty shared and co-federal.
Yeah. We're going to take...
Yes.
So I want to connect what you said, what you suggest with Daniel Loic's idea of usufructus, and suggest that maybe what you indicate is that we need not to follow Daniel to reject property ownership and move to a usufructus idea, but to distinguish between sovereign's own property, right, and the foreigner's property, which whenever the sovereign of one state interferes with, has to regard it as a usufructus. In a sense, the foreign tribe or the local tribe, their property would, for the sovereign, be regarded as usufructus, and that would be a different regime for the management of that property, which might indicate the obligation to co-decision. But if in a situation where you can't do it, you can't obtain the consent you still have to give a very rigorous answer why you don't, why you use this property. And obviously, the inspiration for this argument comes from the law of belligerent occupation, right? Mm-hmm. Where there is a clear positive law obligation to regard the foreigner's property as usufructus, apply usufructus principle to the use of that property. Other than that, I think that the question that you've been asked by Lior, by Jean, by Andrew, suggests that there's something additional. It's not, and I wonder what would be the benefit of using the trusteeship concept here, where we already have useful approaches like collective rights and the self-determination of minorities, and especially indigenous minorities, that do some work. And I don't. You didn't show that that work is ineffective. That needs to be replaced by other ideas.
Thank you. Thank you, first of all, your paper, which is very, very interesting. And I want to go back shortly to the question of legitimacy. And I have a short question as regards this question, as this problem. If we conceive of legitimacy, of a sort of kind of legitimacy, as based on just on legality. My question is, who makes the legal system that is, in this case, at the basis of a non-consent-oriented legitimacy? Who makes it? Tradition, power, wealth, don't know. That's nature. All bad guys in a row. So, and that's the question. Very simple. Who makes the legal system that is at the basis of a non-consent-oriented legitimacy? And one further remark. You use the paradigm of constitutional pluralism to ground your position, and it is interesting because it's not. I think the consequence of this use is that you make use of the concept of trusteeship also in the internal context, and not just toward the external context. That is, I think, it is typical for the paradigm of constitutional pluralism that the consequence is the kind of disaggregation of the state, and I think that it is. I don't agree on this point, but I find it is very interesting. Because the paradigm you adopt has significant consequences on the use of the concept of trusteeship, which can be limited to foreign individuals or groups, or can be extended also to the internal sphere, depending on this theoretical assumption.
Okay.
Thank you.
5 minutes and
okay.
3 more questions.
So the trusteeship model in the case of indigenous peoples and the state, where there's a veto at play, the basic model is with international law. And international law entrusts legal authority to both sovereign legal authority to both indigenous peoples and the state to be exercised in good faith in a collaborative way between them. Now, I think both indigenous peoples and the state could violate principles of good faith negotiation on this model. But that's where, even when there's a veto, the trusteeship model would simply where there's a veto, the trusteeship model essentially appears, most prominently one level up, where international law is really the legal system. That's regulating the relationship. So there's still going to have to be questions. Did the indigenous people actually consent? That might have to be settled by international law. Are indigenous peoples holding out in bad faith? That might potentially be a question that would have to be settled by international law. So the law of belligerent occupation is, of course, near and dear to our hearts, because we see, Evan and I see that as a great instance of the trusteeship model. And the question of, do we need it where there's a veto involved is just sort of is really just the answer that I gave to Andrew. I think it still makes sense for us to think in trusteeship as public powers as fundamentally trustee-like in character, in that the powers that they hold and exercise are never for the benefit of the individuals, but also always for the benefit of those who are subject to them. Sergio, legitimacy, who makes the legal system? Well, I have said that legal authority and political authority, I think, are distinctive, but they aren't distinctive in a way in which they don't occupy silos that are impermeable to one another. And so I think the people make the legal system. I think ideally the people make the legal system. But even where that doesn't happen, even where it's just a monarchy, I think a monarch can be held to certain obligations of legality vis-a-vis his or her people, and if the monarch breaches those, we would think that there's a problem from a legal point of view along the lines that David was suggesting. So I think it's the people. I think legal power is entrusted by law on behalf of the people. Who actually makes it will be contingent. Ideally, in a democracy, it's the people who make the legal system, but it not necessarily so for us to still be able to make fine-grained discriminations about the extent of legitimacy of any particular legal system.
So we'll take the last questions and answers will be given during lunch.
Good.
Okay, so Evan.
Lior had asked my question, but just a brief comment on the veto point. It seems to me that there are a lot of fiduciary relationships where the beneficiary has a right of veto. Think of a lawyer-client relationship, and it's the exercise of the authority, the manner of the exercise that is subject to duties of care and loyalty. So I don't think that's really a problem for your theory.
Thanks.
Two quick comments. One is both, I think, to Hanoch and to Evan, which is you implied that indigenous people have only collective rights. And I think that it's a mistake, because if we respect the system of the indigenous people, we should respect their way to choose how they manage the thing. And in fact, many indigenous people have different merge public and private, or public and collective rights, and you can try to tell them you can only have rights if you argue collective rights is imposing on them a system of law that is not always...
I misspoke if that's what I said.
No, you agreed with Hanoch, so I just want to correct that. The second thing is you write in your paper that United Nations Declaration of Indigenous People is not binding, and I think that this is now open to discussion. I mean, starting already in 2000, Anaya and others started to talk about customary obligation, and recently the International Law Association in 2010 had a committee to look exactly on the whether the certain prescriptions in UNDRIP have already reached the status of customary international law, and the answer has been yes, including right to land. So I think that in that sense we're not talking only on moral obligation, but at least it is debatable or slowly moving into seeing them as customary international law.
Well, if it's customary international law, of course it's binding. It's just the declaration formally isn't. That's all. That's all I was saying.
Okay, I'm Oren Iftachel from Beersheba. I'm actually a legal geographer, so I come from a slightly different perspective, and I'm very glad about this last session, because in the morning I was a bit frustrated that the discussion was so legalized that almost many important aspects of sovereignty itself, that is of legitimacy of power, were not mentioned. But of course the indigenous issue brings that to the fore. And first and foremost is the issue of identity, because in many cultures identity precedes sovereignty, it precedes the states, and this continues to be mainly in a non-West but incredible source of power and authority. And in the West, it's now with indigenous people, you expose this again, that citizenship is not enough, let's say. So I want to ask you in that respect, and with this model of parallel sovereignty that is actually very fruitful, I think, and very promising for democratizing the world, still it begs the questions, and I think Leora asked, is why would it stop with indigenous peoples? And it's not enough to say that it's a special case that they've been colonized, because other people feel colonized even if they're not indigenous. And it's maybe religious communities, maybe women, and in legal geography now there is a whole question of urban sovereignty. Some cities feel that they have the right to determine to have a self-determination, say Brussels as an example. So just to think about the horizontal implications of this kind of opening up the issue of sovereignty.
Thank you.
Okay, thank you. So join me please in thanking both Hanoch and